Good afternoon, everyone. We're just waiting about 30 seconds or a minute as Zoom self-populates. We just want to make sure everyone is actually in the Zoom room before we begin. So we'll just wait about 30 seconds or a minute, and then we'll begin at that time. So thanks very much. Okay. I think we're ready to begin. Good afternoon and welcome to our second webinar in the Trademarks in Canada series. My name is Mark Evans. Next slide, Noel. Thank you. I'm a partner in the trademarks practice at Smart & Biggar, and together with my colleague Noel Engel-Hardy, we'll be speaking on the topic of trademark litigation, oppositions, and non-use cancellation proceedings today. Before we begin, just a few housekeeping matters first. Thankfully for you, our presentation is only going to last about 30 minutes. We will then have an additional 30 minutes for question and answers. We want it to be open, we want it to be interactive, so we can address specific questions that you do raise. In terms of the process for submitting questions, please do it using the question and answer panel at the bottom of the screen. Do not type your questions into chat. We won't have access to questions through the chat panel, and we will try to answer as many questions as possible. If there are leftover questions, if we run out of time, we will try to address those afterwards via email. Also, today's webinar will be recorded, and we will be sending along a recording of the webinar with the slides to everyone afterwards via email. So with that in mind, let's get started. Next slide. Most of you, of course, are familiar with our firm, and we have a deep working relationship with many of you attending today's webinar. Next slide. In relation to trademark contentious proceedings, in particular, we have considerable experience and expertise, and we thought we wanted to share that with you and provide you with a building block for effective strategies in trademark litigation, enforcement, and cancellation proceedings in Canada. In the past several years, the past 5 to 10 years, we've succeeded in numerous trademark infringement trials, numerous appeals of those trials, numerous opposition appeals from the opposition board up to the federal court, and we've handled literally thousands of oppositions and non-use cancellation proceedings over the years. So we thought we would share our background and experience with you. Next slide. So we plan on covering 3 primary topics: Canadian trademark litigation, Canadian opposition proceedings, and non-use cancellation proceedings. And as I said, in 30 minutes or so, there's only so much that we can cover, but we do want to provide you with the fundamental building blocks to develop strategies. Next slide. And Noel, I think that's you.
So for trademark litigation in Canada, there is really 4 main causes of action that would be pursued. The first one is trademark infringement. There's 2 sections of the Act that really govern infringement. One requires that the marks be virtually identical. The second does not require that the marks be identical, but looks to a number of statutory factors to determine the likelihood of confusion and all surrounding circumstances. Then there's a cause of action for passing off. The common law tort of passing off is codified in our Act. And there's also a cause of action for depreciation of goodwill, which prohibits the use of a registered trademark in a manner that's likely to have the effect of depreciating the goodwill of the mark attached thereto. So for this, case law indicates that the marks, they don't have to be identical, but the scope of this is kind of constantly being negotiated by the courts. But the mark for a dilution or depreciation of goodwill claim does have to be registered. And then the final cause of action is an invalidation of registered trademarks under Section 57. There's a limited set of circumstances upon which a trademark can be removed from the register, and these proceed by way of application in the federal court. So typically, most litigation under the Trademarks Act is brought in federal court. The federal court is a court of limited jurisdiction. And so to bring a claim in federal court, the claim needs to have its basis in a piece of federal legislation, of which the Trademarks Act is one. Now, you could also bring claims in provincial court, although this is much less frequently done. There could be situations in which there might be strategic benefits to bringing a claim in federal court, in provincial court, but typically the primary venue would be federal court. Now, in Canada, we have one federal court. There aren't any districts or circuits by jurisdiction. It is one federal court, and there's essentially a roving band of judges that can hear cases from Vancouver to Halifax to Toronto to Montreal. And given our nation's bilingual heritage, we have proceedings can proceed by way in English or French. And typically, there is no single judge assigned to a case. Many IP cases are complex, and so a case management judge or prothonotary may be assigned to help the parties in the early stages settle any discovery motions. The case management is available, and then a new judge would be assigned to hear the trial. And in general, our judges of the federal court are very knowledgeable. Many of the judges are appointed from the IP bar, and you see a really high level of understanding and appreciation for the law and the issues, and just collegiality between the parties and the judges. Mark?
So until a few years ago, there was only one procedure for litigating trademark infringement cases in Canada. It was by way of a so-called action. And that continues to be the most common procedure for trademark infringement claims in Canada. And the procedure is relatively similar to that in the US for trademark infringement proceedings, but there are, of course, differences. Proceeding by way of an action is not blazingly fast, typically. 2 to 3 years is typical to get to trial. Sometimes you can get to trial more quickly by having the court intercede at an early stage and seeking a trial date at the outset. So 18 months is not unknown. The reference to the Pampered Chef litigation is a trial that we handled and went to trial in 2019 successfully. And that, as far as I know, was the quickest case ever to go to trial in Canada in a trademark case. It was 9 months from filing to the trial, and it was a trial that involved fact witnesses, it involved expert witnesses, it involved survey experts before the court, and that was all wrapped up in 9 months. But that was an exceptionally rare situation that, frankly, just arose because of a scheduling opportunity with the federal court. In terms of steps in an action, there's an obligation for each party to list have an affidavit that lists all relevant documents. It is not a situation like in the US where you request documents from the other side. Rather, it's a positive obligation to list all relevant documents. In terms of the examination for discovery, in terms of the actual examination of a witness, it is limited in number and it is limited in scope in the sense that you examine a single representative of the other side who is put forward by the other side. And for those of you attending from the US, it's similar to a 30b-6 situation. So we do not typically have the opportunity to examine a wide range of witnesses. You typically get to examine a single corporate representative before trial, and that's it. The discovery process is very important, including for obtaining admissions. And those admissions, in turn, can be used very helpfully at trial through an agreed statement of facts. the court does want the parties to try to reach some level of agreement as to the statement of facts and issues to narrow the scope of matters. But the agreed statement of facts can also be extremely helpful in terms of setting your case at trial. And then finally, in terms of witnesses, as I said, fact witnesses, survey witnesses, expert witnesses, they all can play a role at trial. In terms of expert witnesses, 10 years ago, our Supreme Court of Canada, in a case called Masterpiece, criticized the use of expert witnesses in trademark infringement cases or trademark cases in general, insofar as expert witnesses are put forward for issues that relate to matters that are within the knowledge and experience of the judge. That doesn't mean expert witnesses can't be used and can't be used successfully where the case pertains to something outside of the typical knowledge of a judge. So, for example, in the Pampered Chef litigation in 2019, we successfully put forward testimony from an expert witness who was able to talk knowingly and knowledgeably about multi-level marketing, which was the channel of trade in that case, and that was very much appreciated by the trial judge. As for surveys, next slide, Noel. We had a case a few years ago in which we successfully represented Diageo concerning their Captain Morgan rum product. The defendant commenced to sell a rum product called Admiral Nelson, and you can see the similarities and differences between the respective products. At trial, we put in a trademark confusion survey. There was about 22-23% confusion level in terms of the respondents. And when the decision came down, the judge made it very clear that he was influenced significantly by the survey. So in terms of trademark infringement surveys, they can play a very important role in connection with trademark cases. Next slide. Pre-trial remedies. Interim and interlocutory injunctions, which are the equivalent to those of you from the US to a TRO or a preliminary injunction. Interim and interlocutory injunctions in trademark cases in Canada, especially in the federal court, have been difficult to obtain over the last 30 years or so. And that is primarily due to the difficulty in establishing irreparable harm. There's case law from our Court of Appeal that goes back and effectively says that irreparable harm needs to be proven. Irreparable harm is harm that could not be compensated for by damages at trial. And that can be very difficult to establish. There is no equivalent to what I understand is now in the US under the Trademark Modernization Act, whereby irreparable harm effectively is presumed if the defendant is engaged in confusing activity. Instead, irreparable harm needs to be proven. That said, pretrial injunctions are granted certainly in clear-cut cases like counterfeiting cases, or where the defendant can't pay damages at trial. And they've also been issued in cases where expert testimony has been proffered and the expert has been able to establish and persuade the judge that irreparable harm in fact would be suffered and that damages at trial simply wouldn't be enough. Another pretrial remedy is the Anton pillar order. This is the civil search and seizure order, commonly used in anti-counterfeiting situations. Important to recognize, though, its purpose is not simply to seize goods from a counterfeiter. Rather, the Anton pillar order requires two different things. One is that there is a strong case of confusion and infringement. And second, more fundamentally, that there is a real and legitimate basis to believe that the defendant would destroy evidence, would destroy materials if they had notice of the case. So therefore, in those situations, you can move on an ex parte basis and take the defendant by surprise and engage in civil search and seizure. Final pretrial remedy, summary trial, can be very effective, whereby either once the defense has been filed or once examinations for discovery have been conducted, you then move for summary trial. By doing so, it's far more cost effective if you've got the right case to do it. It's far more cost effective than a full trial involving live witnesses. And again, by way of example, we had a summary trial in December. The decision came down successfully a couple of months ago, in which the defendant was selling Hostess brand bread. Our client has a trademark registration for Hostess for snack cakes, and the summary trial was heard, and the summary trial itself lasted less than 1 day. So it was very effective based upon the admissions from the examinations for discovery, as well as affidavits and cross-examinations on those affidavits without the need for any live witnesses at trial. Next slide. Trial remedies, a couple of things quickly in terms of trial remedies. If you have a registered trademark, if it is a trademark infringement case, the federal court's injunction will be nationwide. And again, that's a real benefit of having a trademark registration. And it doesn't matter whether you are engaged in commercial activity in the same geographic region as the defendant. As long as there is infringement of a registered trademark, it'll be a nationwide injunction, and you do not need to prove irreparable harm for the permanent injunction at trial. Cost awards. Typically, there's been a growing trend in the federal court to order a lump sum payment. The loser pays, typically, and the typical amount is somewhere between 25 to 33% of all the incurred costs, as well as reasonable disbursements. Other remedies, of course, destruction or delivery up of the offending materials, as well as financially damages, either your damages that you've suffered or the defendant's profits related to the infringing activity, plus interest. Next slide.
So a second procedure available in the federal court specifically is proceeding by way of application. And so this is generally a more expedited and faster and cheaper way to commence trademark litigation. Now, there are several important caveats. An application is commenced by a notice of application. And so here the plaintiff or applicant, it's similar to a statement of claim, and it would set out all of the allegations of the rights that are infringed. The respondent doesn't file a statement of defense, but rather just indicates their intention to defend. But the biggest difference is that there is no real discovery or pretrial depositions. The parties rely on affidavit evidence. Cross-examination on those affidavits is available, and there's no live witnesses at trial. But from a strategic perspective, especially for the applicant, there's no real availability to obtain documents from the other side or to question them. So this is similar to a TTAB proceeding in the United States. And the fact that there's no right to pretrial discovery and no live witnesses is an important strategic consideration, especially if there may be important documents that would be within the possession of the other side. So a significant benefit to proceeding by way of application is that they can be very, very fast. Because there's no right of discovery and the evidence is solely by way of affidavit, these can proceed to trial in 6 to 9 months. That's quite fast. Right now, we have a matter that will be heard at the end of the month, and that was commenced in November. So that is right within the 8-month kind of range. And you're looking at a shorter trial, given that there are no live witnesses, a 1 to 2 day trial rather than a 1 to 2 week trial. And so this can be, especially where all of the documents and financial documents are, within the possession of the applicant, this can be a very appealing way to proceed. And of course, the speed and the fact that there is no real broad discovery can significantly reduce the fees. And so you can be looking at a fee reduction of between 50 to 70%. So this can be, an excellent strategy where the moving party, the applicant, is really not relying on significant document disclosure or financial disclosure from the other side. So again, the risks here, the moving party, the applicant, needs to be confident that it has all the documents it requires to make out its case within its own records. This can be challenging, especially if you're trying to establish damages. Obviously, in this case, you will only be able to prove up the applicant's own lost profits. So this is can be a significant concern. And also, you lose the ability to bring, persuasive witnesses at trial. You are really relying on a paper record, and that just, there may be witnesses who would be excellent at trial, and that is just not available under this proceeding.
Okay, yeah, so let's go in a different direction and talk about opposition proceedings in the Trademarks Office. So every trademark application that is approved by an examiner is vulnerable to opposition. And since 2019 in particular, opposition proceedings have really become more common. They've become more important, and effectively for three reasons. One, we just have more applications being filed in Canada, in part because Canada has now acceded to the Madrid Protocol. So there are more applications flowing into Canada. Two, under the amendments to our Trademarks Act in 2019, it's no longer required for there to be use of a trademark in Canada to obtain a trademark registration. So on the face of it, it is difficult to know without doing an investigation as to whether a trademark is in use. And one's prior use is still the ability to oppose a trademark application. That's still a ground to oppose a trademark application. The third thing is so-called troll filings. Prior to the amendment of our Trademarks Act in 2019, when it was still possible to file a single trademark application for $250 Canadian in government fees covering an unlimited range of goods and services, there were hundreds and hundreds of troll filings that were made. That has dropped off significantly since June of 2019, thanks to the class fee system that's come into place. But nevertheless, those troll filings are there, and many of those have led to oppositions because a lot of those troll filings, including by an individual by the name of Michael Gleisner, who's well known in international circles, filed applications for words that are either inspired by well-known brands or they are generic words in which he's essentially trying to create difficulties for others. So increased importance for oppositions. Next slide, Noel. In terms of the grounds of opposition, there are many different grounds of opposition available. It can be confusion, either in relation to confusion with a registered trademark or one's prior use of an unregistered mark. It can be because the trademark simply isn't inherently registrable because it's clearly descriptive in nature, or it's geographically descriptive, or it's a name or a surname, or that the trademark isn't distinctive, which is something that is of increased importance in Canada, or that in relation to trademarks that were advertised before June 17 of 2019, that there is an incorrect filing basis. So for example, the date of first use that was alleged in the trademark application was incorrect. And then since June 17 of 2019, there is now an opportunity to oppose on the basis of so-called bad faith. An important point in relation to oppositions has to do with the burden. Ultimately, it is the applicant in oppositions in the Trademarks Office on a balance of probabilities that has the legal burden of establishing that a trademark is registrable. However, the initial evidentiary burden is on the opponent. So the applicant effectively doesn't need to worry about anything until the opponent has satisfied that initial evidentiary burden. And that said, that initial evidentiary burden can be rather light, especially for certain grounds of opposition. Next slide.
Sorry.
That's okay. And I think this is you.
Yeah. So in terms of the procedure, an opposition is commenced by the opponent when they file a statement of opposition, and they have 2 months from the date that the trademark is advertised to file that statement of opposition. And that statement of opposition will set out all of the grounds that are alleged, and really, set the stage. The applicant then will file a counter statement, which is typically just a blanket denial of all of the grounds of opposition alleged. The next stage is the opponent's evidence. So the opponent will have basically 4 months from the filing of the counter statement to prepare and file its evidence. That takes the form of 1 or more affidavits, and those are subject to cross-examination. The applicant will then respond with their own evidence, and then the opponent does have the opportunity to file reply evidence. And all of this is potentially subject to cross-examination. There are certain strategies in terms of seeking leave to cross-examine, which can extend then the time upon which the applicant may then have to file their evidence. But you typically have 4 months from the date of the prior party filing their evidence to then file your responding evidence. The next stage would be the written argument, and then which is optional. The parties are not required to file written arguments, and then there is a further optional oral hearing. And the decision of the board may be appealed to the federal court. There is currently a right to file new evidence on appeal. Either party may, although pending changes to the act may limit the ability to file new evidence, and it would be subject to a request for leave to do so. One of the most important things to keep track of in trademark oppositions in terms of evidence is the material dates. The various grounds of opposition each have different material dates. Grounds based on entitlement may actually require evidence as of the filing date of the application. And so oftentimes you're looking at evidence that would need to show activities of the parties several years prior to when you're actually gathering this evidence. And so it can be very important to find, and challenging in many cases, to find admissible evidence speaking to the party's use of marks several years prior, potentially the state of the marketplace several years prior. And so this is something that you really want to keep in mind when you're preparing your evidence, both when you're counseling your client or potentially seeking evidence from an investigator. And so given that, as Mark mentioned, following the changes to the Trademarks Act that no longer require an applicant to indicate whether the mark is in use, investigations have become increasingly important to show both what party had priority and when each party commenced use, as well as proving the state of the marketplace. There are several grounds of opposition that may require or be assisted by evidence that would show whether it's the common adoption of elements of marks that share common elements, or just the use of marks in the marketplace. And so it's very important to consider how this evidence is coming in. In many cases, there can be ways to challenge that evidence if it's introduced through an affidavit of an employee of a law firm for one of the parties. And so investigations are really increasing in importance. Something that's also important to keep in mind is that the opposition board has been often reluctant to give too much credence to foreign activities or the foreign reputation of marks in terms of whether it's a bad faith ground or a ground based on non-entitlement, that where a mark may be well known or used abroad, that may not necessarily be relevant to questions of distinctiveness or entitlement in Canada. Prior to the pandemic, most cross-examinations, the presumption was that they would happen in person. And you really were able to bring a witness, the other party's witness, to examine them, although the cross-examining party would typically bear the duty of some costs. But now with the pandemic, most cross-examinations are happening virtually, and there really is no indication that this will stop once we emerge from the pandemic. One benefit to oppositions as well is that currently there is no cost awarded. So the vast majority of oppositions do settle, and because there is no ability for a party to seek costs against the other, many of these settlements you can just pull the plug essentially at the 11th hour. Now, there are several changes to trademarks opposition procedures that are in the works. As Mark and I have both mentioned, there were significant changes to the Trademarks Act that came into force 2 years ago. Some of the proposed changes are essentially sitting in legislative limbo, and it's unclear when these are going to come through. So one regards cost awards. The government has indicated that cost awards may be available, but this is not yet enacted. Also, case management. Oppositions can be extremely complex and contentious, and there has been an indication amongst the bar that case management could help to expedite oppositions and streamline matters. So this has been sort of flagged, but we don't know when this is going to come into effect. Another important consideration is confidentiality of documents. Currently, any third party is able to request the full file history for any trademark in the trademarks office. And so that means that for parties who seek to file evidence of their own use and reputation of their mark, all of those sales documents, advertising is publicly available. And so the government has indicated that there may be the possibility of obtaining confidentiality, but this is not yet available. And again, the big caveat is that currently there is really no limitation for parties to file new evidence on appeal. But the potential amendments indicate that soon this may be subject to a requirement to seek leave. We don't know when these are coming down. The government has indicated that implementing these proposed amendments is a fairly low priority, but they are on the horizon.
Okay, I think this is me. So let me turn to non-use cancellation proceedings, so-called Section 45 proceedings. And these proceedings, like opposition proceedings, have become extremely important since the changes to our Trademarks Act in 2019, given that it's no longer necessary to have use of a trademark to obtain a trademark registration. So consequently, there are many, many, many registrations issuing in Canada that have never been used in Canada. The procedure for Section 45, non-use cancellation proceedings in the Trademarks Office, is extremely simple. Once the registration is at least 3 years old, it's a simple matter of filing a request with the Trademarks Office and paying the government fee. It can be filed anonymously. You don't need to indicate who the actual client is or who the actual party is. We can file it in our own firm's name, and there is no requirement for any sort of reasonable investigations showing that the mark isn't in use. There's no need for due diligence. None of that will be required by the Trademarks Office. So it's very simple to commence a Section 45 proceeding. Next slide. And that's consistent with the purpose of these non-use cancellation proceedings. They are not intended to be full-blown contentious proceedings, even though they often are. And because the threshold really pertains to whether these marks are dead wood. And consequently, the threshold to maintain a registration is quite low. So for example, in connection with goods, if you have evidence that is clear of a single sale in the normal course of trade at any time during the previous 3-year period for the registered goods, that's all you need to maintain the registration. Now, where it gets a little more complex is if the trademark that is used in the marketplace is not identical to the mark as registered. Generally speaking, as long as the version in use is considered to be an immaterial variant, that will be good enough to maintain the registration. Of course, what constitutes an immaterial variant? There's a lot of jurisprudence on that, not all of which can be easily reconciled. But let me say this, which is that notwithstanding the low threshold to maintain a trademark registration, the Trademarks Office itself, I think, is quite exacting in terms of the evidence that needs to be filed. If there are ambiguities in the evidence, the Trademarks Office will look at that quite hard. So the evidence really does need to be buttoned down in order to maintain that registration, even if the total amount of use is quite small. Next slide.
Sorry.
It's okay.
So an important consideration for Section 45 proceedings is that there is no opportunity for the requesting party to file its own evidence. The evidence is only filed by the trademark owner, and there is no cross-examination available. So this can, this really can drive the proceeding. The board there are inferences that can be drawn, and ambiguities, given the absence of cross-examination, ambiguities will be construed against the registered owner. But this can be a strategic challenge for a requesting party because its only opportunity to poke holes in the evidence is at the written argument or oral hearing stage. So typically, when a Section 45 notice is issued, the registered owner has 3 months to gather and file its evidence, although that deadline can be extended by another 4 months without the need for reasons or consent. Then the registrar will set a date for the parties to submit their written arguments. The requesting party goes first, and then the registrant responds. And then there is an optional oral hearing. There is also a right of appeal to the federal court with the potential to file new evidence, again, subject to the proposed changes with leave being required. But there is also a significant, a significant standard of review issue. The federal court may review the evidence depending on the materiality of the evidence. This can shift the standard of review by the federal court. So again, like the changes that are pending for opposition proceedings, we have a number of changes coming down the pipe, potentially for Section 45s, including cost awards, case management, the confidentiality of documents, and the requirement to seek leave on appeal. Like with opposition proceedings, any evidence filed in a Section 45 is going to be publicly available. So oftentimes clients, will want to be careful with the type of evidence they file showing use, given the low evidentiary threshold and that evidence of even a single sale is sufficient. Often clients don't want to file a fulsome 3-year history of all of their sales, given that would be publicly available.
Okay, so in addition to non-use cancellation proceedings in the Trademarks Office, it's also possible to bring proceedings in the federal court for cancellation of a trademark, but this is really expungement of a registration. And it's expungement of a registration on the basis of grounds of invalidity of the trademark, as well as abandonment of the trademark. And that procedure can be brought in one of 2 different ways. It can be brought as a standalone proceeding. So you may initiate that proceeding by way of affidavits to seek to invalidate a trademark registration. So for example, if a registration has been cited as confusing against an application you are prosecuting in the Trademarks Office, you may proceed on that basis, for example. Alternatively, it is commonly the case that in trademark infringement proceedings, the defendant will include a counterclaim asserting that a trademark is invalid. In terms of invalidity proceedings, only the Federal Court of Canada has the ability to expunge a trademark registration from the register. And in expungement proceedings in the federal court, the burden is on the parties seeking to invalidate the registration. And that, of course, is the opposite of the burden in an opposition proceeding. And that's another reason why ideally, opposition proceedings should be brought in a timely manner rather than waiting for expungement of a registration. I also note that one thing to be careful about and to take note of is how old the trademark registration is. Once the registration is at least 5 years old, some of the grounds of invalidity slip away and the registration becomes at least partially incontestable. So if you are considering expunging a registration on the basis that it isn't valid, you do need to be careful about that 5-year period. And with that, that takes us to the Q&A portion of the presentation. And we really would like to have your questions so we could answer those. As a reminder, you can submit your questions through the Q&A box at the bottom of the screen, just by clicking the button. We do have a few questions. One question, I'll ask you, Noel, in terms of mediation in the federal court for infringement proceedings, is mediation mandatory?
So mediation is not mandatory. It is encouraged. There is a duty on counsel imposed by the federal court's rules to, encourage to seek reasonable settlement. And so mediation is not mandatory, but the court is very willing and able to offer up its services and quite effectively. Some of the case management judges and prothonotarians are very encouraging of settlement and are happy to offer the court's resources and skills to help the parties come to a resolution.
Another question, maybe I'll tackle this one. Does the federal court tend to favor Canadian businesses? And my response to that is absolutely not. In all of my years, I've never seen a hint of any sort of pro-Canadian bias by the federal court. The federal court is very good in terms of ensuring that the decision is just, it's fair, it's equitable, it's in accordance with legal principles. And I can think of various cases I've handled over the years, whether it was the Pampered Chef case a couple of years ago. Pampered Chef is an American company. It's part of the Berkshire Hathaway family, and they were sued by a Canadian company, Loblaws, and the court found in our client's favor. Harley Davidson was a case I had several years ago. Again, they were sued by a party in Quebec, and again, the federal court found in favor of Harley Davidson. So no, I would say there's absolutely no hint of any sort of pro-Canadian bias. Other questions. Is the opposition period extensible? If so, by how long? Noel, do you want to tackle? I can do that, but do you want to?
No, I can take that. So when the trademark is, the application is advertised, so you have an initial 2-month period within which to file a statement of opposition, or there is an extension of time available right there for, I believe it's now up to 4 months. This was changed with the amendments to the Act to file a statement of opposition. And then there are a number of basically extensions of time throughout the proceeding that are available, where they're called there are in many cases cooling off extensions, and they are available for up to 9 months. And the idea really is to encourage the parties to consider settlement and to negotiate. And those are, in most cases, typically readily granted. They do a cooling off requires the consent of both parties. But the vast majority of oppositions do settle before the conclusion, and a lot of that settlement activity happens through these cooling off extensions. Now, those extensions are not necessarily available for applications filed by Madrid. There are different time periods applicable to oppositions to Madrid applications, and so many of the quite flexible and generous benchmark extensions of time that we as practitioners have been typically used to granting and receiving, it is a slightly different and more compressed time frame under Madrid.
Next question. please
Mark, do you
discuss.
want to
Yeah,
tackle
sure.
this one on amending an application mid-opposition to remove the date of first use?
Well, actually, I'm sorry, I was about to start another one.
Oh,
Sorry.
okay, go ahead.
Yeah, it's all right. I was just, maybe I was doing it out of order. Is it possible to challenge a trademark registration based on descriptiveness and genericness? The answer is absolutely. So both in terms of trademark being descriptive or genericism are definitely grounds of invalidity. It is definitely possible to challenge a registration on those grounds. And furthermore, those grounds do not expire once the registration is 5 years old. The grounds that fall away in terms of a registration being 5 years old really are limited to prior use of your own trademark. That's the ground that disappears after 5 years, unless you can establish that the party adopted their trademark with knowledge of your prior use of your trademark. Here's one, Noel. Are there any circumstances when you would take proceedings in a provincial court rather than the federal court? I can think of a couple. Why don't you?
Yes, there would definitely be certain strategic considerations that might lead you to commence in provincial court. Some provincial courts have indicated a greater willingness to consider certain types of pretrial remedies, such as injunctions. And some, depending on the nature or the business of the parties, it may make more sense to, especially where a business may be focused in one province where there may be specific language issues at play. It may make more sense to seek relief before a provincial court. So again, this would really depend on the facts of the case and the disputed issue, but there are certainly circumstances where a provincial court may, appear to be more willing to grant certain types of relief that would be, very meaningful to the client.
Yeah, let me jump in and add one further thing, which is a related point, because I know we talked about forum shopping really not being something that occurs very often in Canada. And a question that often arises is there a concern about sending a demand letter that a party's then going to run off and seek a declaration of non-infringement? And my reaction has always been that rarely happens. It rarely happens because there's no advantage for a defendant to run off to the federal court. However, that said, if a party is based in one of these provinces in which pre-trial injunctive relief is more possible, I must say we have certainly on some occasions initiated legal proceedings, and we've initiated them in the federal court, so that the first proceeding is in the federal court where any sort of pretrial injunctive relief would be less likely. So, those are a few considerations. Noel, here's a question. What are the most common opposition grounds in Canada? Seeing as though the office examines on relative grounds, is it common that the office misses to cite something that would be needed to trigger the opposition?
So yes, is the short answer. I think also, given that there is very limited grounds for a third party to file any kind of correspondence with the trademarks office, alerting them to the existence of a potentially confusing mark, there's really only 3 specific situations in which you can file correspondence with the trademarks office while a mark is still under examination. So in terms of the common grounds of opposition, you're often looking at what is generally the issue of confusion. And confusion can be raised, whether it's confusion with a registered trademark, confusion with a pending application, or the fact that a confusing mark has been used, whether it's by the opponent or by any number of third parties, that would either render the applicant would then be not entitled to secure registration of the mark, or the mark that the application at issue is not distinctive in light of this confusing use of other marks. So in terms of the most common opposition ground, it's typically related to confusion, and that can kind of be either, claimed or established under, either confusion with registered mark, non-entitlement, or non-distinctiveness. And often those three grounds are raised simultaneously. They each carry different material dates, which can pose different evidentiary concerns depending on when the marks that are potentially confusing started to be used. But the confusion as a broad sort of topic and then narrowed to non-entitlement or non-distinctiveness, those are definitely the most commonly raised, I would say. Mark?
Yeah, no, I agree with that. And of course, the examiners don't know all of the facts. They don't know if a particular brand is especially well known, and certainly in terms of trademarks that are just based upon common law use. I mean, again, so the lots of additional grounds will arise. Here's a question I'll tackle. If disclosure of sales figures is not an option, for example, due to company policies, what are the alternatives or solutions in cases of the trademark to oppose other applications or defending Section 45 proceedings? The easier one is in relation to Section 45 proceedings. You simply don't need to put in evidence of sales in terms of total sales or annual sales figures or anything like that. Some parties do that because they want to put in persuasive evidence showing that the sales are huge. But as I said, the reality is that if you had a single invoice that is established as relating to a sale in the normal course of trade during that 3-year period prior to the commencement of the cancellation proceedings, that's enough. So the disclosure of total sales figures isn't a concern in Section 45 proceedings. Oppositions, that question does arise a fair bit. And typically what is done is you put in what the company is comfortable with. I mean, you do want to put in, a strong case, but sometimes what is done is conservative sales figures are filed with an indication that because the sales figures are considered to be competitively sensitive or confidential, the actual sales figures are much in excess of what is stated within the affidavit. If your registered mark is a square within a big logo, what if in actual use you've added elements such as a generic description or labeling such as the percentage of alcohol, etc., inside the box? Is that considered a material variant in Canada? Maybe, maybe not. Do you want to handle that one, Noel?
Sure. So there is some benchmark case law looking at what constitutes a material variant. And ultimately, the test really looks to the perception of the consumer and whether kind of the dominant elements of the mark have been maintained. And so there is a ton of case law on this issue. And it seems like every time we are faced with this, you can find good cases that go in either direction. But, a lot of it really will come down to kind of a factual analysis and looking at the deviations in use. And it is, these are issues that can be fought quite vigorously. And, even for us, I think we have had cases where we have thought that we had excellent, evidence showing that the deviations were significant and that the trademark as registered would not be perceived as being the trademark as used, and the board has found in the other direction. And so, it really is a matter of sometimes it feels like it's a matter of chance, but it would really depend on, what the consumer's perception of the mark would be. And so, it's hard to really predict. But you're looking at maintaining the dominant elements of the mark and whether that would be perceived by the ultimate consumer.
We've got time for a couple more questions. So under Section 45, if there's no actual sale, but you have evidence of advertisements and a website where people can make an order, is that sufficient to prove use? I'll tackle that one. So in part, it depends upon whether you're looking at goods or services. If you are looking at services, then you don't need to have sales in Canada. and it gets tricky, and there's a lot of jurisprudence on this point. Perhaps the most generous case on this point was a case that I handled many years ago involving the Sports Authority chain of sporting goods stores in the United States. They did not have any stores in Canada. All that they had was a website that could be accessed by Canadians, but Canadians could not purchase anything through the website. It was not an interactive shopping website. Notwithstanding that, the court held that the trademark registration was still in use in Canada based on the website alone, on the basis that the information provided through the website was an ancillary service, and that was sufficient to maintain the trademark registration for services. Now, for goods, it's a different story. Generally speaking, for goods, you do need a sale in Canada, generally. There has been some jurisprudence saying that being ready, willing, and able is enough, but by and large, I would say if it's merely an advertisement, if it's merely a website, if there have been no sales in Canada, that is unlikely to be sufficient to maintain a registration for goods under Section 45. Do you have protest letters in Canada? Noelle, do you want to handle that one?
Sure. So as of June 2019, it is possible to submit. It's called a notification of third-party rights, but there are very, very limited grounds that can be alleged. So it is essentially confusion with a registered trademark, confusion with a pending application, or that the applied for mark contains a registered trademark in the description of goods and services. That's it. So, and there is no real requirement that the office consider those grounds. It goes on file. You see that the letter has been filed. It would be publicly available by anyone seeking the file history, but there's no specific requirement that the Trademarks Office consider it, and they don't respond to your letter. And it gives you the party who files the notification of third-party rights, has no rights at that point in the proceeding. You would still need to commence an opposition to raise any of the other grounds regarding non-distinctiveness, non-entitlement, the fact that the application may not otherwise comply with the requirements of the Act. So it is a very limited procedure. At the same time, if your client has a trademark that you believe to be confusing and it's registered or an application is pending, it's a very cheap and cheerful way of bringing that registration or application to the examiner's attention, but there's no real requirement that the Trademarks Office consider it.
Sadly, we are out of time. So we've reached the end of the scheduled time. There are a few questions we haven't answered yet. We'll gladly respond by email if unless it's anonymous, we don't know who to write to. If anyone has any additional questions afterwards, just shoot us an email. But ultimately, thank you for taking the time and joining us. Our next webinar, we hope you'll join us, is July 8th, and a couple of our colleagues will be presenting on Canadian and US trademark prosecution, northern highlights and key differences that brand owners and counsel should know. So thank you very much.
Thank you.